Liesel Solomon, a conveyancer and associated STBB. Previously, we've covered things to look out for when signing an offer to purchase, which included the foot stewards clause, a notorious term that purchasers and sellers of immovable property may have heard is that of the foot stewards clause. The term foot stewards originates from Roman Dutch law and translates directly to with the shove of a foot. What this term means in the context of immovable property is that the immovable property is sold as is or as it stands. There are two types of defects in immovable property, which we'll discuss later on. So basically, the property is purchased together with all defects that it may have. Latent defects are defects that are not clearly visible to the ordinary man, even if it would be apparent to an expert. These defects may be covered up or concealed and very often only become evident sometime after the date of sale or the date of transfer. For example, a leaking pool or a leaking roof after heavy rain. I am one of those people who have been subjected to that. A patent defect, on the other hand, is a flaw that is not hidden and ought to be easily identified upon a reasonable inspection. A patent defect is clearly visible to the naked eye, for example, cracked gutters, cracked tiles, or a dripping tap. If a purchaser buys a house and afterwards notices that there are certain obvious defects which would have been revealed by reasonably and carefully inspecting the property, then the purchaser has no claim against the seller in the respect of these specific patent defects. The foot stewards clause protects the seller from incurring liability in respect of both latent and patent defects. There are, however, certain qualifications to this in respect of latent defects. Now remember, latent defects are the ones that you can't see. In terms of our common law, there's an implied term in a contract of sale that the seller warrants to the purchaser that there are no latent defects in the property. This means whether or not the contract specifically states it, the seller warrants the absence of any latent defects. As a result, if it appears after the conclusion of an agreement of sale that the latent defect exists, the seller may be liable for those defects whether or not he or she even knew about it. This was confirmed in the Supreme Court case of Odendaal v. Ferreira, where the court stated that if a seller conceals a latent defect in the property intentionally, the seller cannot rely on the foot stewards clause. However, if the defects were brought to the attention of the purchaser, or very importantly, if the purchaser had an opportunity to inspect the defect, the purchaser cannot go back and claim from the seller. The foot stewards clause therefore only protects the seller with regard to latent defects insofar as the seller was honest in not being aware of the problem. Legally, what the purchaser must be able to prove is the following. So firstly, the purchaser must prove that the defect was there at the time of the sale, so when he entered into the agreement of sale, that the seller was aware of the defect, and that the seller did not disclose the defect at the time of the sale. And lastly, that the seller deliberately concealed the defect as he or she knew that if it was not concealed, the purchaser had seen it, the purchaser would either have not continued with the purchase or would have negotiated a more favorable purchase price. So in other words, it must be shown that the seller fraudulently and negligently made a material misrepresentation to the purchaser. Although this is some consolation to a purchaser, the burden of proof or the onus is consequently placed on the purchaser to prove the deliberate concealment with the intention to defraud, and that the seller knew of the defect and did not disclose it. So now the question arises as to what type of claim the purchaser has against the seller if he can prove the points previously listed. It is important here to distinguish between the position before and the position after registration of transfer has taken place. Before registration of transfer, and on the assumption that the defect was material, the purchaser will have the following options. So firstly, he can claim to cancel the agreement of sale outright, or he can keep the contract and claim damages from the seller. So remember, there's always the possibility that the seller will deny having any knowledge of the defect, and therefore the purchaser, to maintain his stance, must have a strong case because he carries this evidentiary burden to prove that the seller knew of the defect and that the seller fraudulently did not disclose it. If it comes across after transfer has been registered, the position is slightly different in that the purchaser will then only be able to claim damages from the seller. He can't cancel the agreement as it's been registered. So therefore, he has to overcome the evidentiary burden to claim these damages. So let's have a look at the facts of Odendaal vs. Ferreira. The particulars in this judgment were that Odendaal put her house on the market and Ferreira, after visiting the property, decided to buy it. At the time of inspecting the property, Ferreira could not access an outbuilding as it was locked, but the estate agent assured Ferreira that it was in a faultless condition and that the pool and the jacuzzi and everything else was in good working order. When Ferreira took occupation of the property before transfer, the existence of some defects became very apparent. The staircase railing collapsed as it was not secured, the ceiling of the outbuilding had partially collapsed, and there was considerable water damage on the floor. There was a sewage manhole cover in the middle of the laundry room, and the jacuzzi was faulty and the pool leaked. The local municipality had then informed Ferreira that Odendaal's predecessors in the title had obtained approval for the outbuilding, but only as a storeroom and subject to a sewage being rerouted. Ferreira then instructed his bank, who were financing the purchase, to put the transaction on hold, pending the settlement of the issues relating to any unauthorized building works. Odendaal then cancelled the agreement and instituted proceedings for Ferreira's eviction from the property. The court confirmed that the footstewards clause covers any hidden defect in the property which prevents or hinders the owner from enjoying ordinary use of the property. So the lack of building permission for the manhole over the sewer and in the outbuilding are defects which interfere with ordinary use of the property. Generally, in order to avoid consequences of the footstewards clause and to walk away from an agreement of immovable property as a result of latent defects, the purchaser will have to prove that the seller knew of the latent defect, did not disclose it, and deliberately concealed it with the intention to defraud. The purchaser was, in Odendaal v. Ferreira, unsuccessful for two reasons. Firstly, most of the issues relating to leakage and broken stair rails, the court held that where the purchaser has an opportunity to inspect the property before buying it, any proceeds to buy with the defects, he will not have recourse against the seller. Ferreira could not hold his failure to inspect the outbuildings against Odendaal and therefore had no justification for instructing his bank to not proceed. This was in effect a repudiation of the contract by Ferreira, which in turn entitled Odendaal to cancel the agreement and claim damages. Secondly, Odendaal bought the property from the erstwhile owners who had erected the buildings. Odendaal therefore had no knowledge herself of this fact, and there was therefore no proof of any fraud on the part of Odendaal. So the moral of the story is that prospective purchasers have a duty to properly inspect all details relating to the immovable property he or she intends to purchase, including the municipal records. Alternatively, a purchaser can insist to include a term in the contract to that effect that the seller warrants, despite the fact that there is a footstewards clause, that the building on the property has the required statutory approval and has been built according to the building plans. As we have seen, the inclusion of a footstewards clause in a deed of sale for immovable property means that the property is purchased as it stands, together with all the defects that it may have. By agreeing to purchase property footstewards, the purchaser effectively exempts the seller from liability for defects in the property sold, unless there was a fraudulent or negligent misrepresentation on the side of a seller. The Consumer Protection Act impacts on the aforegoing position, but to a lesser extent than is often thought. This is because the Act is only relevant if the seller is a supplier, as the term is defined in the Consumer Protection Act, meaning someone transacting in the course of that person's business activities. An example in a property sale transaction is a property developer, where the developer sells a property to a purchaser. The developer is therefore a supplier, and generally this transaction will then be covered by the Act. It will not apply to an atypical transaction for once-off transfers between a private sale, purchaser, and buyer, but it does apply to developments. So when it is determined that a Consumer Protection Act applies to an agreement, then the supplier is obliged to provide a defect-free good to the purchaser. Defect-free is not an absolute, as the Consumer Protection Act requires that the item provided by the supplier must be free from material defects, meaning that the supplier will not be liable if the defect is of a minor nature. In order to comply with the provisions of the Act, a seller can get past this proviso by describing the condition of the home sold in a specific detail to make it clear to the purchaser exactly in which condition the home is being sold. If the purchaser accepts the home in this condition and then agrees to purchase, the implied warranty of quality falls away. So to wrap it up, when a seller wants to sell immovable property privately with the inclusion of the foot stewards clause, he or she has the duty to disclose all defects of the immovable property that he or she is aware of. A seller can further mitigate potential liability by attaching a condition report to the contract of sale. The condition report would essentially be the seller's way of setting out the condition of the property as well as listing all defects he or she knew about. The purchaser similarly has a duty of properly inspecting the property, as the condition report is not a warranty against any defects to the purchaser. The seller may dispute that he or she truthfully did not know of a defect and consequently did not list the defect. It is important to remember that the purchaser is not barred from outsourcing independent professionals to properly inspect the property before he concludes an agreement of sale. So our suggestion to you is to get the proper advice and proper legal counsel before entering into agreement of sale that's subject to a foot stewards clause. Thank you for listening. For more information, go to stbb.co.za.